Call the Board of Selectmen's meeting to order on August 22nd, 2016 at 6:30 p.m. We can all stand for the Pledge of Allegiance, please. Pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
First item on the agenda is the Polish American Citizens Club liquor license violation public hearing. We're revisiting this, and if the members that are interested in being speaking this evening from the Polish American Citizens Club could please come forward.
Yes. Mr. Chairman, if I may, I will recuse myself. I did check with the Ethics Commission. Of course, that's free of charge, just in case anyone figures that there is a fee to that and I'm chinging up money for the town. And since I was a member, my wife currently is a member, my name is still on a list, but I just don't happen to have a paid check mark next to it because I didn't pay, okay? I will recuse myself for this. This way I won't get the board in any trouble. I don't mind me, but the board I won't get in trouble. Okay?
Thank you.
Thank
Duly noted. Sir,
Miller,
please.
Mr. Miller, I regret that you can't hear the argument today, and I hope to see a paid check mark next to your membership next
I
year.
never had the membership thing, so.
I'll rectify that as soon as I can. Thank you. It's good to be back.
Please have a seat.
Too often. Just to recap, and I will be brief. On April 14th, the Webster police reported an incident on Harris Street at the Polish American Citizens Club. The report indicated an arrest of an individual for an open container violation. And quoting, it said, because in fact the individual did possess 2 open beer bottles in public within the town of Webster. On May 10th, at a Selectmen's meeting, the police report was discussed, and according to the minutes, quote unquote, Selectman Becker stated one person was overserved, end quote. On June 13th, there was our hearing, a disciplinary hearing, and by a vote of 3 selectmen, the license of the PACC was suspended for 3 days. The PACC closed for 3 days. As you know, we think that the board erred in its finding of violation, and I thank the board for the opportunity to be heard and reheard. We are of the opinion the board erred in finding a violation, and here's why. 5 points. First point, by your own bylaws, our disciplinary hearing was not timely. Disciplinary hearings are held no later than 4 weeks after receiving notification from the WPD, period. No exceptions. I have copies of the bylaw here. If one's not available to you, I'm happy to approach you. Now, there's reasons for a timely hearing. I get that. Memories are clear, events are clear, witnesses are available. In this matter, I understand that the young man who was arrested in the incident returned from school to his home in California. He is not available for me to ask him, where did you get those open beers that were in your hand? I was unable to ask him if he plotted with the bartenders to escape with open beers. There's reasons for a timely hearing, and this hearing was not timely, according to your bylaws. Point 2. There is evidence that the decision was based on opinions decided with no evidence or with evidence to the contrary. The disciplinary hearing, bear in mind my timeline, the disciplinary hearing was held on June 13th. Yet, on May 10th, 1 month plus 3 days prior, Mr. Becker concluded, and I'll quote, one person was overserved, end quote. Bear in mind that at our hearing, the Webster police stated that there was no probable cause to find that anyone was overserved. I'm aware that Selectman Becker, and I don't mean to be picking on Mr. Becker, but the 2 quotes that came to mind from the minutes, I'm aware that Mr. Becker has since said that he took into account the totality of the situation. I understand that. I'm also aware that at the conclusion of saying you respected the totality of the circumstances, you said, but I was faced with a near riot, quote unquote, near riot. But, Mr. Selectman, pardon me, but I was there. Officers are in the audience today who were there. I was in the parking lot with a Diet Coke. There was no near riot, there was no unholstered gun, there was no riot shields nor tear gas. It was 100 people thereabouts milling around. And I respect the police professionalism in handling the crowd, which was ruly. It was not an unruly crowd, so there was no near riot. And that paints an inflammatory picture of the circumstance. So respectfully, I guess I could summarize that words matter, and to conclude that one person was overserved or that it was a near riot are statements of conclusions and not facts to support a violation of a liquor license violation. My third point. In the hearing on June 13th, the PACC did not have the benefit of seeing the report that was filed. My office, attorney's office in Southbridge, my office contacted the Webster Police, and we were told that we could not have a copy because it may have involved a charge against a juvenile. And I understand that. Those records are often not made available. The courier I spoke with, the contact with the police department, further said the PAC is not implicated. I show up at the hearing. I find out from the police that there was probable cause to find an open container violation against the PACC. Now, having had access to that report, having a chance to respond to a number of the items plus comments made by the police, I see no indication that, in the opinion of the police, the PACC overserved. I see no indication that it served underage, and I certainly see no implication or probable cause that we contributed to a situation that was a quote-unquote near riot. Which brings me to point number 4. A young man was arrested for leaving the club with 2 beers in hand. I don't know where he got the 2 beers. The police report states that he was arrested for Town Ordinance 308-1 because he possessed 2 open alcohol beverages in public. Now, if you're wondering, hey, wait a minute. If I'm on my porch and I walk out with a beer in hand and wave across the street to the neighbor, here's a cold one, have I broken the law in Webster? And the answer to that question is no. 308 does not say that. 308 says that a person shall not consume alcohol on town-owned land. So this person, this individual, this young man who allegedly slipped up the stairs, 2 beers in hand, walking up the stairs into public, walked into public in a parking lot owned by the PACC. He was not on town land. I submit that this was an inappropriate open container violation. And also for the Selectmen, I brought a copy of section ordinance 308-1. And my last point, point 5, is a restaurant, bar, or grocery store in this city, in this town, strictly liable if a person purchases a beer, opens it, and walks out the door? Because I submit that if the answer to that question is yes, then that's a bad policy. Restaurants and bar have a tough business. And now, by implication, this sanction states that if a person slips out the door, this restaurant could be compelled to close for 3, 10, any number of days, or suffer other penalties. I'm unaware of any court case or statute that holds a restaurant or bar liable because a customer left with an open container. Granted, that person has a responsibility under the law to not possess an open container, and certainly not in an automobile. But the restaurant, I submit no. Now, conclusion here, under the statutes, under the general laws of the Commonwealth, this board has the authority to conduct disciplinary hearings with regards to liquor violations, no question. And to complicate that authority that lies with this body, I recognize that this is a political body and not a judicial one. So rules of evidence are different here. I recognize you bear the responsibility without necessarily all the tools to make a judgment as to violation. However, it is imperative that the decision be made on the facts and on the law. And the law is rather clear. For us, don't sell to minors. No free drinks. No more than 2 drinks to a person. There's a list. There's a Commonwealth regulations. We know the rules. We attempt to abide by the rules. And as a body, if we have, as a political body, making a judgment as to our application and whether we have abided by the rules, it's important that you look to the facts and the law and make a decision, because I think that a decision was inappropriately made finding a violation when, by the police's own statement, there was no probable cause to find underage drinking. There was no open container violation under the statute by which the kid was arrested. And if you're of the opinion that you must believe what is right, and your sense of right does not comport with the law and the facts, then you've made the wrong decision. And we submit that it was the wrong decision, and we seek that you consider no violation having occurred. That's my comments.
Any questions or comments from the board?
When you received notice from the police department, how many weeks was the hearing conducted?
9 weeks.
Was there a reason? Sam, do you know? Was it put off for some reason, or quorum reason, or meetings?
It wasn't. It was given to the Board of Selectmen timely, and then there was some posting. Courtney, remind me, posting, and a meeting was canceled, correct? Right. So everything was done timely. And we actually contacted the ABCC to ask if there was an issue with that, and they told us no, because it was acted upon. Even though the hearing didn't occur, it was acted upon.
Okay. And then
The
probably
scheduling
the
of the
meeting
hearing
was
and all that.
canceled because probably a quorum? No quorum or something?
I don't even remember, because again, there's notice requirements and all of that, so we had to start over again.
Yeah,
Mhm.
it wasn't.
That's
posted
right.
On the website, it was a glitch on the website.
Correct.
And then-
Correct.
All right, so needless to say, the ABCC had no problem with
No, the
the
ABCC,
9
because
months.
the board acted on it. You had scheduled a hearing, even though that hearing did not occur, you still acted on it, and that's the
Okay.
requirement.
Mr. Chairman,
Yeah.
before asking any questions, I just think it's appropriate to have the police provide any additional information
Sure.
that they may want to apply.
Officer Shaw?
Hmm?
Okay,
Sorry, Lieutenant.
no worries. Some days I wish I was an officer. All right, a couple things. In regards to the report, all the reports up until around that time, the chief had gone out on his medical leave for a surgery. The executive secretary handles the release of all requests for police reports. She saw that it was an arrest report and didn't realize that it related to the PACC, that the charge related, so that's why the report wasn't released right away. So we've since revamped that policy. I apologize that it wasn't made. I did speak to Mr. Bridgman over the phone regarding the violations around the time he requested it. So we did have a conversation via the telephone about that. Provided the report to him the day after the hearing. In regards to my statement saying there's no probable cause for over-serving, that is incorrect. I heard that the day of the meeting, and I went over there and I watched this meeting on YouTube. And I had other officers watch it. I had Sergeant Wheeler watch it. In my opening remarks, I say that there are two violations that we feel there are probable cause for. The over-serving, which was also backed up with the evidence of the breathalyzer test, and the open container, the young man coming out of the bar with 2 beers who fell into my officers. To quote, "We believe people under 21 consumed alcohol at PACC, however, it doesn't rise to the level of probable cause for a violation." Sergeant Wheeler was told by the persons founding, this is not a quote, that was a direct quote, Sergeant Wheeler, who can testify that he found people hiding in a second floor in a bedroom in an apartment at 3 Lindale, that they were under 21 years old and they did consume alcohol. We didn't have their names, we didn't have their identification, so in the interest of being fair, we didn't bring up the underserving of the alcohol. But, and I said that day as well during the June 13th hearing. Again, I went back and watched it on YouTube. It says that very clearly. You know, in regards to the open container, I've been here 20 years. We've charged people with that numerous times in the past, similar circumstances. It's a civil violation, so what happens at court, I can't track it if they dismiss it or whatnot. I looked up today, I don't know what happened to that. I'd have to go to the courthouse and find out. However, it doesn't change the fact that the person left the establishment with open containers of alcohol. Refresh your memory, scores down on Thompson Road when we had the boat races that used to be on Webster Lake. We had a lot of people from Canada come down, and they would go there, and they were seen leaving that place with open containers of alcohol by Sergeant Hoover. They were not charged, but a violation then ensued, and they were found responsible by the Board of Selectmen. And I believe they lost their license, or whatever the sanctions were, I can't recall. But there was a violation, and they were found responsible by the board. I know that, the open container wasn't the sole reason for the arrest. Okay, there was 100 people. No, was there tear gas and riot shields? Of course not. No, there weren't. But I've been doing this job long enough to know that all it takes is one mouth to get the crowd going. All right? It doesn't take much. The officers, he was handcuffed for safety at that point, with the purposes, I guess, of being placed in protective custody because he was intoxicated. At that point, he began to fight with the police. Sergeant Wheeler can speak further to that. That resulted in the disorderly conduct charge that was found, that was subsequently found to be guilty. If Sergeant Wheeler, I don't know if you have anything to add regarding that night.
We need to make it clear that if we were looking to go out to the PACC, I would have done a much better job. When I approached the scene, there was 100+ people pouring out. As I mentioned before, there was pockets of people having altercations. Was it the fight that we were reported to be responding to? No, but it was a lot of altercations. If Mr. Bridgman was walking around the parking lot drinking a soda, he would have saw me using my best command presence to break up these altercations and to get the people to clear the area. The individual that left the PACC lot stumbled over their front stairs. He walked out of their building with 2 beers. He didn't make it to a car. He didn't pick up the bottles in the parking lot. He stumbled out of the bar into my officer, which was Officer Ham. The beers were removed from his hand. He was taken into custody. As I mentioned the first time, in order to be fair to all the people there, our first intent was to place him in protective custody because he was clearly intoxicated. Calamity ensued. He caught some other charges, and it ultimately had culminated into him fighting Officer Reed in the cell. He took a portable breath test. He was at .192. He didn't stop from stumbling out of the bar. We didn't give him beers in the cruiser. He didn't consume beers at the station. He came directly from PACC and registered at .192. In addition, the kids that were fleeing here and there, one pocket fled to 3 Lindell Ave, which we are familiar with from other past parties from Nichols College. Once we had the PACC lot safe and secured, and we assured that sober drivers were driving people away and there wouldn't be a car accident down the road, we went to 3 Lindell Ave. I found 25 people approximately hiding in a bedroom. I polled them. They admitted at great peril to themselves because they could have been subject to arrest or calling the parents, things of that nature. They admitted that they were under 21. They admitted that they drank at the PACC. Again, assuring their safety and trying to be diligent to the public safety. I didn't stop and say, what is your name, give me your ID, and call the station. I just made sure they get home safely. So, did we have probable cause? Maybe, but we're trying to be fair.
How does 3 Lindale Ave plant this? When the kids rent? They rent that?
Hockey team rents one of the buildings there, the common complex.
It's not uncommon to have the hockey team. I know the hockey team's done it in the past when I used to work midnights. They had a place on Wakefield. A bunch of them get together and get a team house.
Any questions or comments from the board?
Well, one comment, one question I guess I would have for the police representatives is, Mr. Bridgman, Attorney Bridgman is quibbling with the fact that I called it a near riot. Based upon what I read in the 2 police reports, having to have multiple officers called in for this, it is an opinion that I used to call it a near riot. The description of what the bar looked like inside, with glass everywhere and alcohol spewing everywhere, as far as the individual fights that were going on outside or jostling matches that were going outside, that's the term I used, near riot. That is an opinion Attorney Bridgman says it's a conclusion, it is an opinion. That's what I said. He also indicated that I stated for the record that one person was overserved. The police reports that I read indicated that this individual, upon being taken into the police department, had a .192 blood alcohol level, nearly 2.5 times the .08 legal limit. That was the reason I stated one person had been overserved. In addition, with coming out of the establishment with 2 beers in his hand. So I just want to clarify those 2 points. Additionally, just for the record, Mr. Chairman, I have checked also with the Ethics Committee. I was involved in the financing of one of our local restaurants, and the PACC is not considered a competitor of this local restaurant. And in addition, I also researched the fact that in the police report, it indicates that this was a Nichols College event. It was not, in fact, a Nichols College event. Just for the record, it was an event that was put on by a student who happened to be at Nichols College, and it was in no way condoned or funded or had anything to do with any clubs or the college itself. It was an individual event that he promoted. So I just want to make sure that those 2 points are on record.
Thank you. Any other questions, comments from the board? Anything else, gentlemen?
I guess just as rebuttal, I don't know if I would call it rebuttal, because I am appreciative. I actually met you that night at the PACC, and I did a great job in the parking lot. Near Riot, I was not criticizing their observations of the event, I was just criticizing the use of that term as inflammatory. Because it says, upon my arrival, I observed approximately over 100 people hanging out around the front of the building, which could be said of a football game, baseball game, movie theater, any event inside.
But it's not.
Attorney Bridgman, anyone can take any comments in here and claim what they wish. If you read the both reports, you will get a clear picture of what the officers found.
I have one report, not two.
I have Officer Patrolman Reed and Patrolman Hand's reports. I think Officer Reed's may have been
But
the actual arrest, dealing with the arrest.
my point is that they did a professional job, responding to the incident and arresting the young man who was intoxicated. But my point on the open container is this: that statute does not apply to open containers on private land. And I passed it out. You can read that.
I'm not an attorney, but I would look to the police for their comment on that, because I always understood it to be accessible to the public. I'm not an attorney, but I would ask.
We've
Lieutenant
always
Shaw.
charged for it. I've never heard of an issue. It's never been challenged that I'm aware of. But, okay, take that out of it. It doesn't change the fact that alcohol left the bar into the parking lot. It was in the process of doing so when he fell into the officers.
Yes.
Again, scores when they walked out. There were no charges because the guy was from Canada. It was an observation by Sergeant Hoover. We went and notified them, came in front of the board for a violation. They were found guilty, okay? If you want to hang your hat on the violation, I mean, on that, you can take it out. It doesn't change the fact that beer left your club and went into the parking lot. That's the open container.
Which takes me to the point number 5, which is, okay, any restaurant, any bar, any grocery store where a patron leaves that with an open container, does that, out of the strict liability reading, make that establishment responsible and therefore have to close its doors because they allowed a person to walk out the door? There was a recent wedding. It was very hot in the club. Time and time again, we would go outside, and people would go outside to cool off with a drink in their hand and say, listen, you've got to go inside. You've got to go inside. We were continually patrolling that event. We had people at both of the exits taking beer taking beer away when the person exited, if they had a bottle in their hand. Now, if this person escaped with 2 bottles of beer, then he escaped with 2 bottles of beer. And that means he passed the person at the door who was trying to take them away. But the fact that he escaped with 2 bottles of beer, does that make the establishment strictly liable for a liquor violation? And I say if that's the finding, that's bad law. Because suddenly every bar will have to post someone at the door to make sure nobody goes out, because if they do, they will lose their license for a period of time. And that's my fifth point. Yes, you arrested someone at the door with 2 beers in their hand. That was a bad statute. That was public land statute. It's very clear. You don't have to be a lawyer to read that, 2 lines of that statute. It says on land owned by town. That English is very straightforward. But if that person exits with beer in his hand, does that mean the establishment is strictly liable? I say no.
Mr. Chairman, just a question for Attorney Bridgman. Did the club members, did the club officers stand at the door and take any drinks away from one as they were leaving the?
I personally stood at the door, this is the front door, and took drinks away from people exiting, kids exiting that door. There were 2 officers at the back door, and I believe that was the door I'm not sure which door we're talking about.
Back there would be the side cellar door?
Yeah, yeah. That was the one he came from, but there were 2 officers at that door, and I was at the front door taking beer.
Well, it sounds though as if Sergeant Wheeler probably gave you a break by not charging him with being overserved, because then we would have had 2 violations against you. Because they probably could have substantiated that with a .92. The second 1.9.
No, I thought that was the,
.192, right?
that was the other cause for the violation was the over-serving
Right.
for the .192.
Secondly, I believe if you feel that the board is erred, you should have a right to contest that to the ABCC and show them the local law. If they say that you're correct, that it applies to town land, then they'll throw it out. If not, then,
That's correct. Yeah, that's correct. That's an option we have, yes.
okay.
Any other questions or comments from the board?
Yes, to the chairman, I think that the clarification too is, with respect to the alcohol leaving the establishment, when you have a liquor license for serving at a bar or a restaurant, the alcohol purchased at that venue is to be consumed on premise. So if your liquor license, the definition of your premise is defined when you submit your application to both the board and the ABCC, your premise does not extend into your parking lot unless you amend that in your description. So by leaving the door of the club, that's where the problem is with the alcohol.
Yeah, I totally agree with you, Selectman Jolda. And the responsibility of that person with an open container, that's an individual violation in the event he hits town property or gets into an automobile. But my argument is that violation, if we have undertaken procedures to keep the liquor on the premises and within the license, and we have performed that, then we should not be held strictly liable because someone escapes with a beer in his hand.
Any other questions or comments from the board? Gentlemen, we thank you for coming in. We will now close. Actually, let me ask, is there any questions or comments from the audience, as it is a public hearing? Seeing none, we will now close the public hearing, and what's the pleasure of the board?
My recommendation would be for them to go to ABCC if he feels that the open container laws wasn't charged correctly. Go to the ABCC, they'll overturn it. If they feel that the board erred, if the board didn't, then they're gonna uphold the suspension.
Mr. Chairman, I'm not inclined to recommend any change in the vote based on the additional information or clarifications we've heard tonight.
I would be in agreement to upholding our original findings as well.
Does someone want to make a motion to that effect?
Yeah, I'll make a motion to uphold our original finding that there was a violation.
Second.
Motion has been made and seconded to uphold the violation. Any discussion?
I wasn't present at that meeting, so
Courtney, poll
I'll
the board.
abstain, I guess.
Selectman Duggan?
Abstain.
Selectman Jolda?
Yes.
Selectman Becker?
Yes.
Chairman Moore?
Yes, thank you.
Thank you for your
Now we will continue on with our regular meeting. First item on the agenda is Kenny Bezzetti, the Safety Committee recommendations.
Gentlemen, ladies, good evening.
Evening. What you
We
got?
just wanted to give you an update on our last meeting. There's a couple in here that we just wanted to bring before the board, like usual. As you can see, there's 5 of them that came before us as far as maybe new requests. So this is where we stand as far as those 5 streets with a little bit of change of signage here and there and that. If you, I don't know, Mr. Chairman, if you want me to just read them out, or you just want to
Sure.
look at 'em or
You want
ask
to
me
do
a
that? You want me to
question?
do
Sure.
it? You do it?
Yeah, okay.
Go ahead.
That first one, Malden Drive, we just came to a study where we were looking at just adding to the signage that is already on that street, which we're going to put more of a new residential area slow children sign. There's actually 2 of them posted there now, but they're the older style. And we feel that should, you know, really help for what the neighborhood had a couple little concerns in that area. The second one is our Ray Street. These are the houses that are past Dresser Street down towards Robinson and Lincoln. Those residents over there, we had a little letter from them asking us if one side of Ray Street from Dresser Street down is already posted one side parking only. They were asking the same, you know, if that was possible, so after.
Mr. Chairman, that'd be going down to Pepka Drive area, Mike, correct?
Yes,
Okay.
yes, towards Robinson.
Thank you.
And that's on the non-sidewalk side, so it complies with the rest of the street, which was done maybe a previous year ago. So we kind of came to a conclusion on that one also. Third one's right next to it, which is Lincoln and Ray in Robinson. Right now, there is a stop sign on Robinson Street, and we've had a couple of these letters and just asking about this one as far as making that a 3-way stop. There's a lot of traffic, the school, the softball. So, you know, after further looking at some things and a couple, you know, measurements in that area and that stuff, so we came to the conclusion that we would ask that, you know, we do that. We would make that a 3-way stop. The fourth one there, that is the Birch Island area, which is down towards Cedar Drive. We did a lot of research on that and basically came down to the assumption that we felt that the signage was in a good, proper, safe perspective. So we just voted to leave it the way it was. And the last one, Fire Court. I don't know if it rings a bell, because it didn't with me after all these years.
Formerly McQuaid Street. Yeah,
It's the small little strip behind Dunkin' Donuts, that little street. I guess we had a couple from the tenants next to it. Sometimes I guess they just park there. They find cars and they just park there. So we came to the conclusion that, well, there really isn't any signage here. I don't know if they were confused or not. So we do have signage for the parking lot stating it's 2 hours and that. So it's not, it was very simple if we needed to put something on the back of one of them facing that street, just stating that there's no parking on this little cross street. And really, that's all we had for that quarter coming in, so.
Any questions from the board?
I'd make a motion that we accept the recommendations from the Safety Committee.
A through E.
Yes.
Second.
A through E.
Motion's been made and seconded to accept the recommendations of the requests from the Safety Committee, letter A through E.
Mr. Chairman, if I may, just so everyone, just to
Discussion.
remind everyone, D, that was in response to the public hearing that we had here. So the Safety Committee's recommendations are to leave the signs up, so there will not be motorcycle parking allowed in front of waterfront Mary's, as
Any
there is
other-
not now.
Any other discussion? Courtney, pull the board.
Selectman Miller?
Yes.
Selectman Dugovich?
Yes.
Selectman Jolda?
Yes.
Selectman Becker?
Yes.
Chairman Ford?
Yes. Thank you.
Thank you.
Next item is the approval of the new inspectional services fee schedules.
I think Courtney, I was contact you, Ted wouldn't be here.
Oh, yes, we're gonna,
I guess we're gonna postpone
We're
it
gonna
again,
post that,
yes.
that's right.
I wasn't here the other day,
That's
but
correct.
I
I
guess we're postponing it
slipped my
again.
mind.
One more time.
Next item is the acting town administrator's report.
Which consists of this, Mr. Chairman. It's not a report. This, I had given you a draft, I believe, at the last meeting. If anyone has driven by North Main Street, the project has begun. I just wanted to give the Board of Selectmen this. We have finalized the information for the community meeting. It will be August 31st, 2016 at 6 p.m. 18 Village Way, that's the community room at North Village, okay? So if anyone from the community is interested in attending, there will be representatives from FEMA there. I'm sorry, FEMA, oh my goodness. The EPA, not FEMA, the EPA. They will be there. Mr. Jarrell and probably Mr. Murphy will be answering any questions that anyone has, so please feel free to attend if you have any questions or concerns on the project. It's nice to see something happening over there, and it's my understanding, I haven't driven by, but it is my understanding that there's been a lot of work done, so.
Yeah, Mr. Chairman, if I may,
Yes.
I drove by there yesterday and today, and they're sorting everything as we speak with some gigantic machines. I guess they're getting ready to bring in some containers, I think, which will be a feeder onto it. So I guess it's one of the biggest projects that company's ever had.
There'll be trucks in and out of there, and so all of that will be discussed at this meeting, so.
That's great.
Thank you, Mr. Chairman.
All right, that's it for the acting town administrator's report.
I make a motion that we accept the acting town administrator's report.
Second.
I wasn't gonna go down that road,
Not
but
what
any
it is.
discussion? Courtney, pull the board.
Selectman Miller?
Yes.
Selectman Dugovich?
Yes.
Selectman Jolda?
Yes.
Selectman Becker?
Yes.
Chairman Ford?
Yes. Old business, the part-time recreation director position job description, which we were just handed this evening.
Yes.
Might I make a recommendation that we read this and then we put it on the next agenda?
So move, Mr. Chairman.
Motion's been made. I don't think we really need it.
I
We'll just
would.
put it,
I would,
well, I,
for the record, because somebody say you're just passing it on.
no,
It'll appear on the next one.
we just got it 2 minutes ago, so.
And please, feel free to contact me individually if you have any concerns or anything, or feel something should be added or not be in here or anything like that, and we can make the changes before the next meeting. So at the next meeting, you can approve it and we can advertise it.
Perfect. Any other old business? New business, future Board of Selectmen meeting dates we have in front of us, and I will read them out. In September, Monday, September 12th, 2016, 7 p.m., and they're, unless I say differently, they're all at 7 p.m. Monday, September 26th, 2016. Tuesday, October 11th, 2016. Monday, October 17th, 2016, which will be at Bartlett High School, and we'll be meeting at 6:30 p.m. Monday, October 24th, 2016. Monday, November 7th, 2016. Monday, November 21st, 2016. Monday, December 5th, 2016. And Monday, December 19th, 2016. Is everyone good with these dates? Very good.
Yep.
Next item on the agenda is to open the October 17, 2016 annual town meeting warrant, and I will ask Selectman Jolda if you would like to read this, not to put you on the spot.
Not a problem. So the annual town meeting will be held on Monday, October 17th at 7 p.m. at the Bartlett High School Auditorium. The timeline is as follows. We're opening the warrant today, Monday, August 22nd, 2016. The notice of the annual town meeting will be published Friday, August 26th. All petitions from department heads are due by 4:00 p.m. Thursday, September 15th. All petitions by committees, boards, and commissions are due by 4 p.m. Thursday, September 15th. All citizens' petitions are due by 4 p.m. Thursday, September 15th. And then the warrant for the meeting will be sent to town council for review on September 19th. And then the Board of Selectmen will review and approve the town meeting warrant on Monday, September 26th.
I'll entertain a motion.
So moved, Mr. Chairman. Courtney.
Second.
Motion has been made and seconded. Any discussion? Courtney, call the board.
Selectman Miller?
Yes.
Selectman Degevich?
Yes.
Selectman Jolda?
Yes.
Selectman Becker?
Yes.
Chairman Porter?
Yes. Next item is the vote to accept the $120,000 grant from the Fells Family Foundation to supplement the FY17 Police Department budget. Acting Town Administrator.
Actually, the chief is here, so I want to ask him and to maybe come up and, again, the Fells Foundation is wonderful to the town of Webster, and we are fortunate to have these people in our community, and they care about the community, and this grant is because of the failed attempt at the override for the 2 additional police officers for the police department. We met with Mr. Fells, and he feels strongly about public safety. He's made that, everyone's aware of that based on the building across the street. And he just feels it's very important that the chief has said that he needs 2 additional officers, and he wants to provide him with the resources so that he can do that, so.
Chief.
Well, I mean, I don't think I have to tell the board how gracious Mr. and Mrs. Fells are and what they mean to the town. And as the town administrator has said, they both feel very strongly about public safety. They both are well aware of the needs that we have and the manpower issues that we have. And again, as that override had failed, they felt strongly that going forward is the right thing to do. So Mr. Fells approached me and asked me if we would be willing to accept that. We wrote out a grant, and Lieutenant Shaw wrote a grant out, and we have decided to go forward with that, and here we are.
That's great. They are so good to this town. It's remarkable.
Amazing.
What is the pleasure of the board?
So moved, Mr. Chairman.
Second.
So make a motion that we
Please.
accept the
And could we
grant
send
with
a-
extreme gratitude.
Absolutely.
A motion's been made and seconded. Any discussion?
Could we just drop them a note? Would they shy away from that? Would it just an appreciation from the board and the police
Well, I-
department?
I'm
I'm sure you.
great if
sure
the
the
board
board
could as
will-
well.
yes,
I have
sure.
said
I think it
something on
would
behalf of the
behoove
police
us to
department.
do that,
Right.
if that's
I would
okay.
add that to the motion.
Thank you.
Courtney, call the board.
Selectman Miller?
Yes.
Selectman Degevich?
Yes.
Selectman Jolda?
Yes.
Selectman Becker?
Yes.
Chairman Porter?
Yes. And thank you so much.
Well, thank you.
And we thank the Fells family from the bottom of our hearts. Next item on the agenda is the Saints Constantine and Helen Greek Orthodox Church one-day liquor license request Saturday, September 10th, 2016, from 11 a.m. to 10 p.m., and Sunday, September 11th, 2016, from 11 a.m. to 6 p.m.
Mr. Chairman, I'd move that the board give the one-day liquor license to Saints Constantine and Helen Greek Orthodox Church for their annual festivities with a great hoopah. Yes.
Second.
Motion's been made and seconded. Any other discussion?
It's a lot of fun.
Courtney, poll the board.
Selectman Miller?
Yes.
Selectman D'Argennis?
Yes.
Selectman Jordan?
Yes.
Selectman Becker?
Yes.
Chairman Porter?
Yes. Any other new business? Informational mail. We are in receipt of a Webster Police Department report for a violation of PACC. So I wanted to see if we can schedule an appointment for, not an appointment, schedule a public hearing for this on September 12th. We are in the right time frame. Am I correct?
Yes.
30 days, within
4 weeks.
Yes.
Someone wants to make that motion?
So moved.
Second.
Motion has been made and seconded to do a public hearing at, is 6:30 okay? 6:30 on September 12th for the PACC violation, new violation, public hearing.
Mr. Chairman, just a quick question on, has the PACC been made aware of
Do you
this
know if they've
violation?
been made aware?
We haven't notified them, so I'm sure they're aware of it through the course of the investigation, but we haven't told them that there's no.
Okay.
So we, the board would send them a notification, just so they were,
We did speak today about the police report,
We-
making sure that,
We will formally notify them and provide them with a copy of the police report,
thank you.
so that,
When? So that we're,
I just need the names redacted from.
Okay,
names
from the report.
to go over.
okay, so,
yes.
okay,
We're not even gonna ask for them to request a copy, we're going to provide it
okay.
when we notify them of the public hearing.
Just with the names redacted.
Yes,
All right.
yes.
Motion's been made and seconded. Any other discussion? Courtney, poll the board.
Selectman Miller?
Yes.
Selectman D'Argennis?
Yes.
Selectman Jordan?
Yes.
Selectman Becker?
Yes.
Chairman Porter?
Yes. Any other informational mail? No other informational mail. We will now go into, are we coming back, Pam?
No,
No.
there's no need to come back.
We're going into executive session. We are not coming back into regular session. Executive session to discuss strategy with respect to collective bargaining of litigation if an open meeting may have a detrimental effect on the bargaining or litigating position of the public body and the chair so declares. Landfill solar facility. Entertain a motion?
So moved.
Second.
Motion's been made and seconded. Courtney, poll the board.
Selectman Miller?
Yes.
Selectman D'Argennis?
Yes.
Selectman Jordan?
Yes.
Selectman Becker?
Yes.
Chairman Porter?
Yes.